Well, good morning, and thank you for joining today's seminar. My name's Nick Storrs, and I'm a partner in the Disputes and Investigations team in Taylor Wessing's London office. And I'm very pleased to be chairing today's seminar in what are, without question, extraordinary times for businesses and individuals. Businesses across the globe have had to undergo rapid change, moving to new working methods and swiftly enacting business continuity strategies. And one question that has been thrown up in what the impact of global events is on commercial agreements with distributors, suppliers, customers, and other third parties. And of course, what parties' rights are, where meeting obligations becomes commercially difficult and in some cases impossible. In today's seminar, we will be exploring some of those issues by reference to the law of frustration and force majeure, and how these doctrines are applied in 5 different jurisdictions: England, France, Germany, Dubai, and China. To take us through these issues, I'm delighted to introduce our expert panel for the session. We will hear first from Laurence Lieberman, one of my partners in the Disputes and Investigations team in London. Laurence is an expert in life sciences disputes and regularly represents UK and international pharmaceutical, biotech, and other life sciences companies. Laurence will give the view from England and Wales. We will next turn to France and be joined by Evelyne Friedel. Evelyne heads the life sciences sector group in Paris and advises clients on many of the commercial aspects affecting their operations in France and Europe. After France, we'll turn to Germany, where we will be joined by Manja Epping. Manja is head of the life sciences industry group in Germany. She has long-standing experience in advising pharmaceutical and biotech companies, and her practice focuses on advising clients on complex cross-border projects. We will then move east to Dubai, where we will be joined by Paul Blakeway. Paul is a commercial disputes lawyer and advises clients on commercial matters affecting businesses in Dubai. And finally, we'll move to China and be joined by Thomas Pattloch. Thomas is based in Germany and leads the China-focused intellectual property group. He has well over a decade of experience in advising on matters relating to Chinese investment, and will be sharing some of his experiences advising on matters affecting China at this particular time. So thank you to the panel for joining. A quick word first, though, on questions before we move to Laurence. There will hopefully be some time at the end for questions, so please message those in. If we do not manage to answer your questions at the end, we will endeavour to come back to you separately after the seminar. So Laurence, from an English point of view, a lot has been said about frustration and force majeure in the past few weeks. Is there a difference between these two concepts? And if so, how does that affect how parties should behave in these times?
Great, thanks, Nick, and good morning to everybody who's tuned in for the seminar. Yeah, I think we've been doing a lot of work advising clients on whether they might be able to rely on force majeure or frustration, which are obviously different doctrines, and I thought it would be useful just to sort of set out the key points around both by way of a compare and contrast in order to illustrate that point. So starting off with force majeure in the first instance. So force majeure is obviously a creature of the contract itself. So the starting point for considering whether you might rely on a force majeure clause, or in fact are faced with someone relying on a force majeure clause, is to look at the drafting of the contract in question. The test, the classic test in English law for force majeure has a number of limbs to it, and I'll just go through those. The first is that the event that gave rise to a party's non-performance under the contract falls within the definition of force majeure in that contract, and that the non-performance was caused by the relevant event in question. And I think it's worth emphasising there that people sometimes miss this point. It was caused and only caused by the relevant event in question. So if, for example, there are two causes, one of them is not the force majeure event, then that's not enough. And that's the English case of Tullow. The second limb is that the event and the non-performance were due to circumstances beyond the party's control. And the third is that there were no reasonable steps that could have been taken to avoid or mitigate the event or its consequences. So what do we glean from all of that? Obviously, as I said at the start, the drafting of the force majeure clause is critical. If the clause, and they come in obviously many different shapes and sizes, so obviously the first port of call is to carefully scrutinise your particular clause. If the clause only refers to performance of the obligations being prevented by the relevant event, then a party may not be able to rely on the clause if performance has just been made more difficult or delayed, but not completely prevented. You do have clauses which refer to performance being hindered or delayed, and obviously those are slightly wider. They may be more generous to the person that wants to rely on the clause in question. You can have lists of events in force majeure clauses. So you can have various different natural disasters, acts of state, or more specific industry-related matters. And you also can have wording which says including those events. If you've got a clause which has a general force majeure, but then says including certain acts, that tends to be more widely interpreted. Particularly if, for example, the specific event doesn't refer to a pandemic, you might be able to argue that if it's including, then the wider list that isn't specified might include the pandemic. Force majeure doesn't include economic problems like insufficient funds, and that's obviously because there's a duty to mitigate. And there's an English case, Candrin, which arose out of the 07-08 financial collapse, where it was said that that was not a force majeure event entitling a purchaser not to complete on an aircraft sale. So it just became more expensive, but it was not something that meant that the performance was not possible. Unless a clause provides for termination as a result of force majeure, termination isn't automatic. If it does provide for termination, obviously you should check on the surviving provisions after termination and what the consequences of termination are. Subject to the language of the clause itself, as I said, typically a party, if it can rely on a force majeure event, is excused from performing or has its performance suspended and has no liability for failure to perform. And obviously, if it can't rely on the force majeure clause, then the usual claim for damages for breach of contract will apply. So then just briefly contrasting it with frustration. So English common law jurisprudence places contractual certainty and enforceability above everything else. And there's a long line of cases going back a long time on that. But in 1863, the classic frustration doctrine came about in the case of Taylor and Caldwell, which is the case which people may be familiar with about the music hall, where somebody wanted to hire a music hall to put on some event, and the music hall burnt down. And that was really the first time that the courts recognised that it was impossible for that contract to be performed. So force majeure is related to frustration, but the obvious big difference is that frustration is when an unforeseen event makes performance impossible through no fault of the parties, but the contract has not catered for that particular event. The effect is that all parties are discharged if the contract's frustrated. All money paid or payable is recoverable, less paid expenses, and that's a consequence of the statute, the Law Reform Frustrated Contracts Act, 1943. Just a case to sort of illustrate that then, there was a case of Howell and Coupland where this was a contract to supply potatoes, and frustration was held to apply because there was a blight which destroyed all of the crops. There was also the SARS case. There was a case in relation to the SARS epidemic, and Thomas may speak a bit more about this himself later, where a tenant, this was a Hong Kong case, a tenant was unable to rely upon the existence of SARS to justify terminating a 2-year lease as a result of a 10-day isolation order in relation to SARS. But of course, this is an unfolding event, and it may be that if isolation is for 3 months and the lease was for 6 months, then the courts might look at that differently. One final point, Nick, on frustration is which is important to remember is there's no such thing as temporary frustration. So if a contract is frustrated, that is a permanent that has a permanent effect. Contrast that with force majeure, where, as I mentioned before, again depending on language, suspension of performance is actually quite common in force majeure clauses.
That's very interesting. Just very quickly then, just in terms of behaviour, I think many parties will be concerned about meeting obligations at this time. What steps should they take to manage any exposure created by obligations which are perhaps difficult to perform at this time?
So I think there's a number of practical steps that parties can take. I think that particularly given the duty of mitigation, parties should be thinking about whether it might be possible to, for example, source from an alternative supplier if it's a supply contract. Parties obviously should get in touch with their contract counterparty. Everybody will be aware of the impact that COVID-19 is having on business relationships internationally, as you mentioned before. And to see whether it, is possible to agree a delay or price variations or whatever is commercially fair and reasonable in the circumstances. Those would be the two obvious starting points, I think.
That's very helpful. And Evelyne, then just turning then to France and looking at this from a French law perspective, comparing with England, there are, I believe, some differences in what force majeure means and how the doctrine might be applied in the current climate. So the question I think to you is, how does French law look at force majeure, and what are the key issues that you are seeing for clients operating in France at the moment?
Yeah, thank you very much, Nick. Indeed, I mean, there are some differences between both jurisdictions regarding the definition of force majeure, the legal instruments we may have, and the issues that clients are facing today. And of course, what I may say is that as in the England and Wales, it is very important to look at the specific provisions of the agreement, which may somehow widen the legal instruments which are permitted under French law. But before doing so, what indeed are the legal instruments in France to cope the consequences of the COVID-19 legal instruments? These legal instruments are provided by our civil code. So there are two specific legal instruments, and of course the force majeure instrument, and also a very new instrument, which is the permission to renegotiate the agreement in case of unforeseen circumstances. So coming to the force majeure instrument, as we know, in the case of a force majeure event, an enterprise may suspend or terminate the performance of its obligations. And the force majeure event constitutes a cause of exoneration from liability. But under our code, a force majeure is an event beyond control. We all know that. Unforeseeable. We also know that. And the effects of which cannot be avoided. So that's the most important criteria to be taken into account. And in the present situation, although our Minister of Economy has indicated in speeches that the current situation should be considered as a case of force majeure, it's important to know that French courts have very rarely, if not never, considered that epidemics were unforeseeable, and especially when epidemics are subject to studies and media coverage on a global scale, as in the present case. That said, what we could plead before court is that the scale of the COVID-19 might probably have not been foreseeable. And of course, what is not foreseeable are all the recent governmental decisions ordering movement restrictions, the closing of some economic activities, etc. But coming back to the third criteria, which is, the effects of which cannot be avoided. This means an effective and genuine impossibility to perform the obligation, to comply with the contractual obligation. So it's not only a difficulty to perform, it's really an impossibility to perform it. So in each case, there is a need of a case-by-case analysis. And so also what needs to be taken into account is that even in case of impossibility, there are some specific obligations for which we cannot use the force majeure instrument. The French Supreme Court never considered that the force majeure event can be invoked to suspend or terminate a payment obligation. And this is, of course, very important in the case of commercial agreements where, of course, one of the parties has to comply with its payment obligation. So, as you can see, force majeure under French law is not an easy instrument if you only rely on the strict legal criteria and case law interpretation. So aside of the legal and case law criteria, it remains important to pay attention to the contractual provisions of the agreement at stake. Because in many cases, and as explained by Laurence, and this would be the same in the French law, provisions may indeed widen the possibility to rely on the force majeure by listing specific events such as epidemics, for example, and also widen the possibilities to suspend the execution of the agreement in the interest of both parties. For example, by providing strong difficulties, high difficulties, instead of impossibility to perform. That said, if the force majeure instrument cannot be used, aside of this instrument, the second instrument, recently introduced in our civil code, allows the parties to request for the renegotiation of their agreement in case of unforeseen circumstances. This is a new approach under French rules. This is a similar approach as hardship provisions generally retained in international agreements. So to benefit from this new instrument, three conditions must be met. A change in circumstances unforeseeable at the time the agreement was signed. And this change must make the execution of the agreement excessively onerous. And of course, the party affected by the occurrence of these circumstances must not have accepted in the agreement to assume the risk. In our case, the unforeseen consequences of the COVID-19 at the time of the conclusion of an agreement could certainly be retained for those agreements concluded before the outbreak of the epidemic in China. But as indicated, the event must also render the execution of the agreement excessively onerous. This cannot be a simple difficulty of performance caused by the situation or a drop in profitability. French case law, again, is quite severe in the interpretation of these legal instruments. Thus, attention must be paid again to the provisions of the agreement. These provisions can define what an excessively expensive performance means. Some elements of the agreement can again widen the scope of this notion and facilitate the renegotiation of the agreement between the parties. last thing to be kept in mind is that during the renegotiation process, the parties must still pursue the execution of their agreement until a new agreement is reached within a reasonable time. And in the absence of a satisfactory negotiation, the parties may terminate their agreement or refer the matter to a judge to decide between the different proposals. So that, as a practical matter, our advice is really to have a business-oriented approach to say, okay, if the parties were ready to renegotiate in case of hardship, I mean, the best really to understand from the supplier and from the distributor, from the purchaser, is to understand that it's in both interests to keep both parties alive in the case at stake, and to renegotiate maybe with a business approach more than with a strict legal or contractual approach.
That's very interesting, Evelyn, and that hardship provision is certainly something which is interesting and does create a practical solution in many respects to some of these issues. Yeah. But I just wanted to go back quickly on one point. You mentioned that the minister had said that the COVID-19 pandemic ought really to be regarded as a force majeure event. And just quickly, do you anticipate, therefore, seeing a lot of commercial parties in France, or at least who have arrangements governed by French law, looking to try to avoid contracts on the grounds of force majeure in light of those comments?
Yes, and not only I anticipate it, but I've also noted it for now, well, since, mid-March. For sure, many parties sometimes abuse, actually, of these notions and tend to avoid their obligation they could, still perform. And many parties just forgot, I mean, this specific notion of impossibility, and notably some parties refuse to pay, for example, which is not sustainable, and which is certainly not what our Minister of Economy tried, to explain. So it's always very important to advise clients in this respect and to say, okay, this cannot truly be avoided. And we need to defend many clients on these issues. But of course, I mean, and notwithstanding what the minister has said, courts might be in the future case law might probably look at COVID-19 as an unforeseeable situation, because it's not an epidemic as any others we could have known in the past. But that said, the criteria of impossibility remains, and certainly the French Supreme Court will certainly still sustain its case law under which an obligation of payment is still binding, and especially, and of course, if the other party has performed its own obligation. Otherwise, I mean, for sure, there is no obligation of payment if the other party was in the impossibility to perform. But once it is done, then the other party has to pay, and especially today because banks can help as well. So it's true that what we have noted is certainly a tendency to use, but sometimes also to abuse of these notions. And that's why the hardship provision, the hardship approach might be easier and more appropriate in many cases.
That's very interesting. And so just turning Manja then to Germany and looking at how that compares to the approach that under German law. As I understand it, the approach to force majeure is, in Germany at least, is not all that different to how it is approached in England, but there are similar hardship provisions under German law as there might be in France. Can you perhaps explain a little how they operate in Germany and what the options are for clients who are facing issues in Germany and in relation to their German operations?
Yeah, thank you very much, Nick. I'd be happy to take a look at the German perspective. And as you say, there are lots of similarities for the concept of force majeure under English law and under French law. So the German position is not totally different. And I would like to recall at the beginning that force majeure is not a general statutory legal concept under German law. It is, however, recognized in special areas of law, such as the travel contracts. And in this respect, the German courts came up with a definition saying that force majeure is considered as an external event that cannot be avoided even by exercising the utmost care that can reasonably be expected. And they also have recognized epidemics and some official measures like embargoes or restrictions of production as force majeure events, which could then dispense the obliged party from its performance obligations. But as I said, that's only a special area of law. That being said, the concept of force majeure is of course also known in contracts. So the parties are free to incorporate force majeure clauses in contracts governed by German law, and they can deviate from the concept, as also Evelyne said, for the French position, and make the concept maybe more lenient for a supplier, for example, of goods. So there are many examples for that, and it's of course reasonable now from the current perspective to include epidemics or pandemics as at least as examples of force majeure in the clause, and it's also it's also a very good idea, for example, to include in a supply relationship, to include critical suppliers of raw materials in the force majeure clause, and I come to this point later when we talk about impossibility. So also under German law, we see the clauses like stipulating the conditions of force majeure, but also the consequences, such as suspension of performance obligations and termination rights, very often coupled to a certain defined notice period. And there's a lot of flexibility for parties to create these types of clauses. I would also like to recall that apart from the specific force majeure clauses, the parties are free to provide for a certain allocation of risk in the contract, and it's really a good idea to look at these provisions like binding or non-binding character of timelines, mechanisms of price adjustments, liability clauses. So all these clauses will prevail over the statutory provisions and will also help to apply the statutory provisions once it comes to this case. So talking about the statute, what happens if the parties have not agreed on a force majeure clause or they have not fully allocated the risk? So what mechanisms does German law know to help contracts that are parties that are struggling with their contracts? So German law also knows the notion of impossibility that's enshrined in the civil code, and the impossibility is a concept of actual or legal impossibility, and it must be separated from a mere difficulty to perform. It can apply, for example, when there's a ban on exports of certain, let's say, medical goods for the supplier of this good, or due to other restrictions that, for example, imposed by the German authorities under the recently amended Act for the Prevention of Infectious Diseases, which gives the government lots of possibilities to interact and with businesses. It may be interesting to note that German courts are also recognize foreign measures of foreign authorities. They're not obliged to recognize them legally, but at least as a fact, which making a performance impossible. But that being said, if only a party's supplier, let's say the supplier of raw materials mentioned before, is not able to deliver, that doesn't mean that the supplier is not liable vis-a-vis its customer. It's not a question of impossibility because the supplier is under an obligation to procure the raw materials, let's say worldwide on the market, and even if the costs are considerably higher, that would not be considered a case of impossibility. However, we have other mechanisms saying that if there's a gross disproportionality between the burden on the provider and the the burden on the provider and the creditor's interest in the performance, then there is under very, very exceptional circumstances the possibility for the supplier to refuse a performance. But this is, as I said, dependent on a weighing of interests between the party affected by the hindrance and the other party. So in many cases, this clause does not apply. Just one thing to mention: if the party is free from its primary performance, that does not already mean that it's totally free from any liability. So normally in these cases, the courts would look at who is responsible for this impossibility to perform, and only if the party under this hindrance is not responsible, then it would be totally free also from secondary obligations like damages, and the other party is able still to or is freed from the consideration to be paid for this for the impossible performance, and has also the right to terminate the contract. So this is the law of impossibility. And as you mentioned already, Nick, also under German law, there's another tool given to parties that find themselves in an unexpected situation and in a really burdensome situation, but that are not allowed to refuse performance because there's still an interest of the other party in this performance, on overweighing or similar interest of the creditor, the other party in the performance, and this is the right to adjustment of the contract. So that's quite similar to what Evelyne told us about the French situation, and it is called loss of business basis under German law, or Wegfall der Geschäftsgrundlage, and it's also enshrined in the civil code, has been codified in 2002. Before that, it was based on the good faith principle. The conditions for that is that the agreement was put under certain expectations of the parties, and there's a totally unexpected and substantial change of the circumstances that the parties were relying on when they were concluding the contract. And very possibly, so COVID-19 would be considered as such a substantial change, which was objectively unforeseen and certainly unexpected. And in case that this condition unreasonably affects the economic situation of one party, it's unreasonably burdensome for one party, and it's outside of the scope of such parties' contractual responsibility, then there might be this. Then there is a claim for adjustment of the contract, which will in practice also mean renegotiation or a claim to the court for adjustment that has to be, of course, then proposed by the claimant. The last criterion, that it must be outside the scope of the party's contractual responsibility, is a very high threshold, and leads to the fact that it's very, very rarely applied by the court. It's really an exceptional means that is given to the parties, but in these again, in these very exceptional circumstances we are currently in, it is expected that we have that this principle of loss of business basis will be applied in certain circumstances. Let me give one example where this might come into play. For example, if due to COVID-19 the prices for procuring medical equipment have massively increased on the world market, but the unexpected price increase is not reflected in the agreement between the supplier and its customer, because normally medical equipment is not a good where the prices are fluctuating so much. So in this case, the supplier cannot refuse performance under the impossibility provisions because its interest does not outweigh the customer's interest, because obviously the customer is also highly interested in receiving the medical equipment. In this case, the adjustment of the contract might come into play, which might be a price adjustment increase of the purchase price to be paid by the customer to the supplier for the procurement of the equipment. Yeah, so this is in a nutshell what I wanted to say about Germany. One last remark, maybe in brackets. If the contract is under German law and it does not explicitly exclude the Vienna Convention in the international sale of goods, then all these questions will be governed by the Vienna Convention, and in Article 79 you will find a special force majeure clause in the convention, which is a little bit different from what I've told you here. So also the choice of law clauses should be carefully done, and you should look at the consequences of this choice. And I would like to conclude here for Germany.
Thank you, Manja. That's very helpful, and it is a good reminder of the applicability of the CISG to some jurisdictions and the relations between contractual parties. So thank you for that. And so, but if we were to move, so just moving east now, Paul, to Dubai, and looking at how the courts in Dubai approach the issue of frustration and force majeure, what's the position in the Emirates?
Thank you, Nick, and may I just say thank you again to everybody for joining us today. In the UAE, the starting point, as we've already seen with France, Germany, and the advice we've received from England, is that the courts, first of all, will always go straight to the terms of the contract agreed between the parties. Particularly in the UAE, it's common that contracts in this space are usually with government entities, which means they'll be very robust, and they will contain provisions on things such as suspension, termination, and force majeure. The point for this is that really the courts take a very strict line on contractual interpretation in the UAE. And indeed, if you have things such as notice provisions and you don't comply with them in order to invoke a force majeure properly, you may find that your rights are extinguished or that any claims ultimately then fail. Another one, as we've seen from France and Germany, is particularly around the definition of what force majeure is within the contract. It may be that epidemics are expressly excluded, or it may be that if force majeure is proven, rights to claim are severely curtailed or simply limited to, for instance, pausing the obligations under the contract until the event of force majeure has passed. Now, if your contract is silent on force majeure, or maybe if your contract doesn't sufficiently define the circumstances or the tests that need to be applied to ascertain whether a force majeure event arises, this is where the law of the UAE can intervene. I've referred to on my slide Article 273 of the UAE's Civil Procedure Code. This contains steps not dissimilar to France, and they can be interpreted very, very strictly indeed. In order to establish that a force majeure has arisen, the first condition that you'll need to demonstrate or comply with is that the performance of the contract has become impossible. Now, this can be temporary or permanent impossibility, but cannot be something which simply makes the performance of the contract harder or more expensive. The term impossibility has not been the subject of many tests in the courts here, certainly not within the context of a pandemic, but it is understood to be treated literally in the same manner that all contracts in the UAE will be interpreted strictly on their clear wording. The second condition that you need to satisfy is that the event itself must be unforeseeable by both parties. Now, taken together, these provisions do create a very high threshold for a party to establish, and it's understood that being viewed in that light, the courts will not relax these sorts of requirements and will set a very high bar in order to establish a force majeure. The exact position that the UAE courts will take in terms of the COVID-19 pandemic is unclear and is untested, but the general view amongst the legal community here is that the unprecedented nature of the pandemic means that the courts may have little choice but to refer to it as a force majeure event, particularly as at the moment we are on an almost complete lockdown. Individuals, unless they work in key sectors, are having to apply expressly for permits even to go to the shops. And this is a country that relies so heavily on the availability of global supply chains that realistically a significant amount of economic disruption will be caused, and there will be a lot of companies that do need the benefit of a reprieve. Now, establishing force majeure through the courts can have quite serious consequences. Technically, under the law, if force majeure is demonstrated, then the contracts will be automatically cancelled. This restores the parties to their pre-contractual state, and no compensation will be due. Particularly if you work for government entities, this may be an issue, and it may result in you being unable to participate in future tenders for those companies in the future. If the force majeure is temporary, there is a possibility that the courts may simply try and intervene in the contract mechanism and adjust the performance requirements or some of the more burdensome obligations while the force majeure exists. However, an important caveat to that is that the creditor, in the event of a temporary force majeure being declared, still has a right to terminate the contract. So even if it's not automatically terminated by the courts, the creditor will still have the option to do that on their own volition. One of the other options available to parties in the UAE, which is generally referred to as frustration, but is more akin to the sort of hardship provisions mentioned by my French and German colleagues. This is under Article 249, which applies where the contract is rendered harder to perform. The actual terms of the statute say that the contract needs to have become more burdensome, and that the event causing that burden, quote, threatens heavy losses. So this would apply in circumstances where delivery times can no longer be guaranteed, or where there would be a change in the economic balance of the contract. It's phrased as being able to be relied upon when there is a public, exceptional, unpredictable circumstance. Now, public circumstances are not defined in the statute, but would usually be taken to mean such as the introduction of a new statute, which would make performance more burdensome and or may result in heavy losses. There's a general view here that this Article 249, the hardship provision, would potentially kick in for the COVID-19 pandemic. And if you successfully bring an argument under this Article 249, the courts can intervene in the contract mechanism in order to change the obligations or pause performance. But that is always taken in a manner that will weigh up the interests of both parties in the transaction. And again, if one of those entities is a government entity, that may also be taken into account as a matter of public interest in terms of keeping contracts being performed and indeed keeping the country moving. Interestingly, this Article 249, the hardship provision, is a mandatory provision under UAE law, so cannot be excluded in the contract. Now, one of the other points that is interesting, and this arises under any circumstances in any contract, is there's an article of the UAE Civil Code, Article 247, which simply arises when there's a lack of or a failure of reciprocity in the contract. So this would enable a party to withhold performance if their counterparty has failed to perform. So it's commonly used where goods are not delivered, meaning that you would not be required to pay in terms of the timing of the contract mechanism. But this is commonly used very regularly in the UAE as a defense for non-performance, simply saying, well, I'm not the one who defaulted first. And the reason why I'm raising this is because it can arise separately, even if you're not prepared to go down the hardship or the force majeure line, but certainly can be used where there is a genuine failure in reciprocity, just to open the negotiations and commercial discussions with the parties in order to try and facilitate some sort of bridging arrangement as opposed to taking a stronger legal path. Now, those are the sort of three key options available for clients, and indeed they're the lines of inquiry that we're getting into our team at the moment, since COVID-19 developed into a global pandemic. One thing that I should hasten to add, though, and I'm afraid this is sort of like a footnote warning that I've mentioned in my slide, is that I've quoted today UAE federal law. This is set by the UAE government, but is implemented differently in each of the 7 Emirates. So, for instance, the way it's dealt with in the courts of Abu Dhabi may be different to Dubai. The UAE also has a number of free zones, such as the Dubai International Finance Centre, that has its own legal system heavily based on the English. So the health warning is that the options I've discussed today very much apply to Dubai, but if your contract is governed by DIFC law or it refers to the jurisdiction of, for instance, Abu Dhabi or Ras Al Khaimah, please do reach out separately to me and I'll be happy to address any of the specific issues that may arise in that jurisdiction, just to make sure that the sort of the advice that we've given today is a bit more specific to your circumstances.
Well, thank you for that, and that's very helpful and a useful warning that the Emirates have different systems in the different Emirates, potentially, depending on how the local courts interpret things. Thomas, then, just turning finally to China. China has in many respects been the focus of the pandemic and was experiencing issues before the virus spread to Europe. And in some ways that means they have been having to think about these things for a little longer than we have. And there is also a history of pandemic or epidemic related issues affecting China. What are the key issues which clients in China are facing at the moment?
Yes, thank you, Nick, and good morning and good afternoon to everyone joining us in this seminar. China is indeed, as you said, Nick, before, it's a country which has some experience in dealing with problems of virus outbreaks or epidemics. And it is the country which had to face the whole problem first and has done so through a lot of measures. And the first thing one needs to understand before thinking about can I claim a force majeure event or can I do something on the legal end, is also to take into account that China is very big and that a lot of local measures have been passed by local governments, provinces, cities, counties, which resulted in effect into inaccessibility of certain factories, in fines handed out if workers were not protected properly by masks, in the famous 50% rule for offices, so that only half of the staff was even allowed to enter, and in Beijing even still is only allowed to enter, even though the situation has abated a bit. That means that Chinese companies had to face and have to face a lot of problems still on the ground, which are not only on the national level, and they are likely to have problems which are quite unknown to us at the moment. We are now experiencing a discussion also in our countries, which leads then in turn to the problem that a number of claims and a number of difficult circumstances are likely to become subject of disputes going forward, maybe not immediately, but in the coming months. Now, when you look at the development on the ground in China, you will find that the Chinese are very entrepreneurial. They're taking charge of the opportunities which this epidemic and pandemic now presents from a commercial aspect in the life sciences sector. And I'm sure every one of us has already received the emails offering masks, disinfectants, and other very necessary products during these times of crisis. Now, the production and everything is ramping up very quickly. For masks, you can see that since February already, there are more than 110 million units of N95 rated medical masks. And for such type of products, which can also be subject to supply contracts or to cooperation with China, one needs to note that these are also medical device goods, which are not always freeable exportable, which require some legal approval by the NMPA in order to be exported, and that may also cause problems down the road. To be specific, as of April this year, April 1, 2020, Chinese exporters of medical products, including the 2009 new COVID test kits, medical face masks, medical protective suits, ventilators, and infrared thermometers, need to provide extra documentation when they go through customs clearance. And that means there's a joint notice of the Ministry of Commerce, of the Customs, and the NMPA, and the documentation in either print or digital form must contain a declaration that the products have been officially registered in China, must have obtained the Chinese registration certificate of medical device. This is the so-called green list. I'm sure many of our listeners today have already heard about. And they must meet the quality control standards of respective export destinations. And customs will only release the exports based on the strength of the certificates of registration. And this means that among those medical devices which are now exported from China to other countries, you need to have paperwork in place, and your contractual partner needs to show this paperwork, which is really quite also now a great run by various companies to obtain. And with that kind of practical point, I would like to turn to some of the legal issues which under Chinese law do play a role. The first thing one needs to have in the back of the mind is that actually Chinese contract law is very strict as regards the implementation of obligations agreed in a contract. It's not so easy to step out of a contract. It's not so easy to say, oh, I have difficulties, I can't perform now. There are lots of remedies and lots of claims which can be caused during problems of implementation of the contract. And there is a strong statutory basis in the contract law and in the general rules of civil law now, which gives quite a number of claims in case of problems. Now, contracts can agree freely about termination grounds, about what to do in terms of delay, what in terms of to do of force majeure events. But if not, it often boils down then to the question which applicable law will be actually used if there is a dispute. An important point to be careful about is that in Western countries, say for supply contracts, for technical service contracts, etc., the judgment of what is the characteristic performance which gives the most significant relationship with the contract is quite different interpreted in China. There is a certain tendency to apply Chinese law. And if you end up in Chinese law, there are, of course, some obligations which you may not have under English, French, or other jurisdictions. That means that one has to be very careful to, and this is really an advice to follow, to try to determine the law, even if there's just a shipment, even if there's just a purchase order. But one should also be careful if you try to agree on the law in general terms, because the law on governing general terms, the civil law, is quite strict, and it may also cause problems if also the Chinese side has conflicting general terms. Again, for all the contracts, it's quite likely that you will end up with Chinese law, although you'd think in my jurisdiction this should be judged differently. Now, Chinese case law has some case law on SARS-related cases in particular. There are not, to my knowledge, any disputes already decided at a higher level during the current crisis. And this case law gives an important lesson, that is that most of the times it will be quite difficult to rely on force majeure. And Chinese attorneys will be very reluctant to say, let's rely on this for Chinese clients or for foreign clients. There is a statutory basis in the Chinese law in Article 180 of the General Rules of Civil Law, not the General Principles of Civil Law, which also apply, but in a different way, and Article 117 and 118 Contract Law, which governs force majeure. They require a situation which is unforeseeable at the time of conclusion of a contract. It must further be unavoidable in terms of occurrence and impact. And finally, it must be unsurmountable. It must be impossible to overcome. In addition, you need a causal link between the situation and inabilities to perform the obligation as required. And under the contract law, you must notify and you have a duty to mitigate the circumstances, notify the other party and mitigate the circumstances to make sure that your obligation is not aggravated, that the situation is not aggravated by that. Force majeure events under Chinese law do in principle not apply to any monetary payment obligations. So you can't say, oh, it has become difficult in the Chinese market, I can't do this, and therefore there's a force majeure event. Change of market situation or monetary payment obligations still must be complied with. The same is true if there is already a pandemic or epidemic and you agree on a contract during that time, knowing about the circumstances. So for those contracts which are concluded now, it will probably much harder, much more difficult to rely on a force majeure defense. In case of a dispute, and that is also born on our, or coming from our experience, it's quite likely that if you do try to enforce claims, if you do try to go either to courts or to arbitration organizations, counterclaims are almost certain to arise. And therefore, the wording of the contract, how the contract is structured, the depth of the stipulations you find in the contract can be very, very important to protect your business and to make sure that there is a basis of argument why a claim of the other side, a counterclaim, should be rejected. There's also another element, as my previous speakers have already mentioned in Chinese law, which is not directly related to force majeure. It's a kind of a clause which allows to set aside or to amend the contract if there are certain changes, material adverse changes to the fundamental assumptions upon which the parties relied when they entered into the contract. And such change must be outside the sphere of regular commercial risks, and it would make the continued performance of the contract on its original terms clearly inequitable to the affected party. And under this rule, which during the SARS time, by a notice of the Supreme People's Court, which then was later on rescinded again, may grant wide discretion of the court to deal with cases. And there are cases, Laurence has just mentioned one in Hong Kong, but there are other cases as well in the shipping sector, for example, where it was tried to say that circumstances change, we have problems. but the courts are very reluctant, are very precise in the analysis of where this impact is coming from, whether it is clearly unavoidable, whether it makes the whole implementation of the contract clearly inequitable. In a nutshell, it's very difficult procedural-wise and as regards the evidence and as regards the readiness of Chinese courts to apply this additional remedy. It will not be easy for either side to do so. And there are very, very few instances where a contract is really set aside or a termination right is granted. In most cases, there will be difficult circumstances, there will be problems, and if the courts have to decide, they will likely move towards a kind of decision based on their common understanding of similar contracts and what should be done under the given circumstances. Which leads down to the question of if you have a force majeure clause, and you have probably also indemnification clauses and termination rights, it's again quite a risk, and I know that in practice it does happen a lot. It's quite a risk to rely on very short contracts and to rely only on the written law. The written Chinese law gives quite a number of termination rights, also in case of material changes, and then leads to disputes of whether the circumstances really justify a termination or whether there's just a modification warranted. In the end, what we can see in China is a great caution, a very cautious approach towards force majeure and frustration of contract, case law, and even under statutory law with very high requirements. Although one must also see that it's quite likely that Chinese counterparts, if they do have problems, they might really raise it. And as I said in the beginning of my intervention, there is indeed a lot of local case law, local restrictions, which do make it difficult for factories to operate normally. Beijing has given already the order for everything to start up again, and in many regions, this was actually rejected by local governments and was basically not implemented in spite of the orders from Beijing. CCPIT, that's the China Commercial Council for the Promotion of International Trade, has tried to help Chinese companies by issuing certificates, regional certificates also, which basically state that there is a force majeure event which has been recognized by governments or by chambers of commerce, or they certify that there is a certain restriction in a certain locality. In effect, legally speaking, these certificates for sure are not binding on any court. So they will be a kind of a first evidence, a prima facie evidence, but they will not really be decisive enough to rely on solely. And in the end, it will boil down to a case-by-case evaluation, whether indeed a force majeure event or a frustration of the contract can be granted under Chinese law. In summary, the situation, if it does come to a dispute in China, will require a lot of local investigation, what really happened in that locality where the contractual partner is located. And it will require a lot of good drafting language in the contracts in order to be successful with a claim. Again, short contracts are often preferred by Chinese providers, but if there is a dispute, usually, according to our experience, they prove to be detrimental to the one making a claim. That's for the moment, in a nutshell, the situation in China. Thank you very much, Nick. I'll give the floor back to you.
Thomas, thank you very much. And it's going to be very interesting to see how those certificates play out and what the impact of those are going to be on terms of how parties behave and how the courts react to them. Thank you all for explaining those issues in what is a difficult time for a lot of businesses and individuals. Time is not on our side, but I would like to take at least one question which has been sent in. The question is this: has Taylor Wessing seen a spike in parties trying to rely on force majeure to exit contracts, and are there trends forming yet in relation to coronavirus in this context? It's a very relevant question in terms of monitoring how developments are progressing at this rapidly moving time. I was wondering, Laurence, have you seen anything, and are you able to comment on that in any way?
Yeah, sure. I'll just say a few things briefly. I mean, the short answer is yes, of course, we've seen a spike in clients approaching us whether to test with us whether they might be able to rely upon a force majeure clause, or that the counterparty is seeking to rely on a force majeure clause. I think there's a few things to just sort of say. The first thing is one has to be very careful about asserting force majeure, and then it is found that it doesn't apply as an excuse for non-performance, and then the party asserting it wrongly is found to be in repudiation of the contract. So careful language, careful drafting, and careful consideration, is something that we're advising clients generally. Just a sort of few things which are a bit more sector specific as well, which we're starting to think about. There's obviously a whole range of different agreements in the life sciences sector that we advise on, and parties' rights and obligations, from supplier agreements, distribution agreements, co-development agreements, collaboration agreements, and so on. And there's all sorts of interesting issues that come up around this. As we've said before, with supplier obligations, those might be suspended during a force majeure event, but the supplier is often required in these clauses to do its best to do a workaround. You also find that often there are exclusive supply agreements in the life sciences sector, but it may be that the purchaser is permitted to obtain the product from a third party if the supplier cannot provide the product during the force majeure event without that purchaser being in breach. There'll be issues to consider around whether a supplier might want to exercise its discretion not to accept an order, and you see those quite often in life sciences supply agreements. We've talked about some of the issues, the difficulties with stock and production and storage, as well as a result of COVID-19 and the unavailability of workforce and transport, and all of those may be arguments that the companies in this sector might put forward. Just very briefly then, in relation to a couple of other issues, if you have a co-development agreement between two parties, sometimes we see in those agreements that one of the parties has to obtain marketing approval from a regulator for a particular product, and sometimes a contractual deadline is imposed for that. If, as a result of this particular pandemic, the regulator is delayed in providing that approval, but the contractual deadline is a committed one in the contract, might clients in this sector think about alleging frustration as a justification for not being able to meet their contractual deadline? I think that's something that we'll see more of. Generally speaking, alternative and modified marketing authorizations might be something that the parties to the contract want to think about. And obviously, the timing of when one raises or is met with a force majeure argument will also be relevant in terms of the particular stages in a co-development project where certain key events along the way become more expensive, perhaps clinical trials, perhaps regulatory submissions. And so before those costs are incurred, it may be that the parties want to discuss. Just very quickly, last point as well. I've also seen in life sciences contracts unforeseen events clauses in the context of collaborations. And that is not a force majeure clause, but given the experimental nature of a number of collaborations in the life sciences sector, you do see unforeseen events clauses as excusing performance or delaying performance. And it's just important for clients to remember to look to see whether they have an unforeseen event clause as well as a force majeure clause. There's a whole host of different issues, contract specific. I haven't even touched upon M&A deals. And obviously, if anybody would like to discuss some more specifics, delighted to do so after the call.
Thank you, Laurence. And thank you to everyone else who's sent in questions. We will endeavour to come back to each of those separately after this seminar. Our time is up. but it does lead me to thank the panel once more for guiding us all through those issues, and to thank you all for attending. If there are questions that arise out of the seminar today, do reach out to any of us and we will do our very best to answer them. So thank you all for attending, and have a very good afternoon.